What happens if the person you're talking to tells you that they have horrible psychological distress? They're depressed, they're traumatized about what happened, but they don't have any physical injury. Nothing physical happened to them. Is this the type of case you want to get involved in? I'm going to share something with you that in more than 26 years of practice, I'm going to suggest to you that you run away as fast as you can in cases that have only psychological damages. Now, that's not to say they don't have valid cases. And it's not to say that their injuries are any less important than physical ones. But there's a huge challenge and a huge problem with proving the case, because most of the time these people who suffer psychological damages alone typically have a history of problems. They come with a lot of baggage. And being able to distinguish what they had in the past with how they're focusing now and how they're dealing now, that becomes very challenging and very difficult. Let me share with you a great example. Let's say a woman is pregnant, 39 weeks pregnant, ready to deliver, and through carelessness by the gynecologist, the baby dies in utero. Dies. And the mother believes that something was done wrong, and had they recognized the baby was in distress before the baby ultimately died, that they could have induced labor and delivered this child who would have otherwise been healthy. Now, can you bring a lawsuit for the wrongful death of a baby who dies before being born? Yes or no? Shout it out. I can't hear you.
Not New York.
Correct. You cannot bring a case for a baby who is unborn who dies in utero. But the law in New York will allow the mother to bring a lawsuit for injuries that she personally suffered as a result of the baby dying in utero. Sometimes she'll have a physical injury. Many times she'll only have a psychological injury. Should you take that type of case? Well, you will find that most, and myself included, most good trial attorneys who handle these cases will typically not want to get involved in taking a case only on psychological damages. Again, that's not to say they don't have a valid case, and there are some attorneys who will take that. But keep that in mind as you're talking to this grieving parent, because it's a tragic situation, but it's not a case you really want to get involved in. Okay, how about informed consent? Let's say the person you're chatting with tells you, the doctor didn't tell me I could suffer the risk that I could go blind from the cataract surgery. Do you take a case like that? Don't you have to ask a few more questions about what the doctor told this patient about whether or not one of the risks associated with this cataract surgery was going blind? Absolutely. Mrs. Jones, tell me what the doctor told you. Oh, he told me I could suffer infection, bleeding, injury to another adjacent organ. Okay. Let's change this up a bit. Let's say there are no physical injuries, but the patient suffered a complication that's a risk of the procedure, had massive bleeding, she needed transfusions. Do you take a case like that? Where the patient turns around and says, the doctor didn't tell me I could have bleeding during the surgery. If the case only involves informed consent, where the patient was not given enough information to make an educated decision about whether or not they should go ahead with the surgery, do you take a case like that? In my opinion, the answer is absolutely not. And here's why. The patient is always going to argue, the doctor didn't tell me this is a risk of the procedure. And now the doctor comes in for his deposition, and I ask him, doctor, what did you tell the patient were the risks? Oh, of course I told her that one of the risks was infection. And in addition, it's in the informed consent sheet that she signed. So then it becomes a he said, she said scenario. It's not a battle of the experts. It's a battle of credibility between a plaintiff and a defendant. So who does the jury believe? The injured patient or the doctor with 25 years of experience and all these great qualifications? In most cases, the jury is going to believe the doctor. And here's a quick stat for you. In New York, the majority of medical malpractice cases, about 95% of them that are brought, settle prior to trial. Of those 5% that go to trial, the majority of those cases are won by the doctors. So, unlike a car accident case or a simple negligence case, if you think you can simply file a case to try and get money from an insurance company representing a doctor or a hospital, you are 100% mistaken. They do not settle these cases. They fight you tooth and nail, and if they do decide It is only after discovery. It's only as the case is on the trial calendar as you're approaching trial, unless you've got a clear smoking gun and it's obvious, and then everybody can agree on the amount. But that doesn't happen that often. So don't believe that you could simply send off a letter to the insurance company and they're going to bow down and give you everything you want. It doesn't happen that way.